Good day, dear listeners. It's Lena again, and I'm so glad you're here with me today. Before we begin, please take a moment to subscribe to the channel and tap the like button. It helps these stories reach the people who need them. And tell me in the comments which city you're listening from. I love seeing just how far these stories travel. My father-in-law said the power of attorney meant he could handle everything. It had a one-page scope limitation he'd never noticed. Neither had anyone else until the transfer went through. Stay close. Because the most powerful document in an estate isn't always the one that does the most. Sometimes it's the one page that says, "This far," and no further. We hand over authority because we are tired, or grieving, or simply overwhelmed. We say, "Handle this," and the person we hand it to handles it, often in ways we did not intend. Ellen Crowley trusted her father-in-law to manage her late husband's affairs during the worst year of her life. She trusted him completely, and when she finally read the document she had signed, she realized that the law had been protecting her from him the entire time, quietly, precisely, in language she had not thought to look for, in the copy she had filed in a folder in her dead husband's office. This is a story about grief and paperwork, and what happens when a grieving person holds on to an original document without quite knowing why. Ellen Crowley is 43 years old. She lives in Columbus, Ohio, in a house in the Short North neighborhood that she and her husband Daniel chose for its high ceilings and its proximity to the art district he loved and the coffee shops she needed. She is a freelance graphic designer, corporate branding primarily with some publication work, and she has the designer's specific relationship with documents. She notices spacing, typeface, kerning, the way text sits on a page. She has always noticed these things, in the way that professional attention to visual detail becomes habitual and applies itself to everything, not only to the work. She did not apply it to the power of attorney she signed in the second month after Daniel's death. She was barely sleeping. She was functioning at the level of survival, which is the level most people operate at during acute grief, meeting the essential requirements of the day and not much more. She had been caring for Daniel through 4 years of a degenerative illness that took him slowly, and when he finally died in the spring, she found that the exhaustion she had been carrying was not grief's antechamber, but its floor, and the floor was lower than she had anticipated. Harold Crowley, Daniel's father, arrived at that moment with the specific confidence of a man who has always organized things and believes that organization is a form of love. He is 72, a retired commercial lender, a man whose career involved the careful administration of other people's financial decisions, and who has treated his own judgment on financial matters as a substitute for conversation for as long as Ellen has known him. Daniel used to say, about his father, he decides first and discusses when cornered. It was not an entirely affectionate description, but it was accurate. Harold arrived the week after Daniel's funeral with a list. The list was organized. The list had headers. It described the estate tasks that needed to be completed, the probate filing, the property and brokerage accounts, the rental property management, the tax filings, and it had timelines and assignments. Ellen had looked at the list and felt something close to relief. She did not have the capacity at that moment to organize a list of estate tasks. She barely had the capacity to make coffee. Harold said, "You're going through enough. Give me the power of attorney and I'll sort it all out." Ellen said yes. It seemed like the obvious answer. The power of attorney document was prepared by Harold's attorney, a Franklin County estate attorney whom Harold had used for years. Ellen did not retain her own attorney for the signing. She did not read the document in the thorough way that documents of that kind deserve. She read it in the way that people read documents during grief, which is to say she registered that it was a legal instrument related to Daniel's estate, she identified the places where she was supposed to sign, and she signed. Harold witnessed. She took a copy. He took a copy and had the document filed. The copy she took went into a folder in Daniel's home office, the office she had not reorganized since his death. The office that still had his books on the shelves in the order he had organized them, and his pens in the cup on the desk, and his handwriting on the whiteboard calendar he had kept for project tracking. She was not ready to touch that room. The folder went in because the folder needed to go somewhere, and that room was where Daniel had kept his papers. That was the copy that saved her. Let me tell you about Daniel's home office, because it matters to this story more than I have said. Daniel Crowley was meticulous in the specific way of people who have managed serious illness with grace, he had learned. Over 4 years of diagnosis and treatment and progression, that the things outside his control were many and the things within his control were few, and that the things within his control deserved careful attention as a form of dignity. He kept files. He kept records. He organized his medical documentation and his financial records and his professional papers with the deliberateness of someone who understood that these documents would need to be navigable by someone else at some point, and who wanted that navigability to be a final act of care for the person who would be left navigating. Ellen had understood this about Daniel, understood it without him having to say it explicitly, and she had honored it by not touching the office. She had not reorganized the files. She had not cleared the desk. She had added the power of attorney folder to the system, as Daniel would have, correctly filed, correctly placed, in the location where the related documents lived. She had done this without thinking about it. It was simply what the room required. The office remained Daniel's for the better part of a year. Meanwhile, Harold was sorting things out. He had, within 8 months of Daniel's death, transferred Daniel's rental property, a Columbus duplex in the Italian Village neighborhood, appraised at $620,000, generating $3,200 per month in rental income, into a family LLC that Harold controlled, and that he had established shortly after Daniel's funeral. He had also moved Daniel's brokerage assets, a portfolio in the low to mid 6 figures, into a new brokerage account in the LLC name. He sent Ellen quarterly summary statements on LLC letterhead. The statements were organized and professional. They included balance figures and distribution projections. They used the word optimization frequently. When Ellen asked questions, Harold said, "Better for taxes." He said it with the calm authority of a retired commercial lender who has spent decades speaking to people about financial structures, and with the specific confidence of a man who has decided in advance that the question has been answered and the conversation is therefore complete. Better for Taxes ended 6 different conversations over those 8 months. Ellen did not pursue the matter. She was still sleeping poorly. She was returning to work in small increments. She was trying to locate the person she had been before 4 years of caregiving and acute loss had reorganized her interior. It was only when she began working with Pamela Vance on a full estate accounting that the picture came into focus. Pamela Vance is 48 years old and has been practicing estate and asset recovery law in Columbus for 19 years. She is the kind of attorney who asks for original documents as a habit before any other step. because she has encountered enough instances of discrepancy between copies to know that the copy says is not the same statement as the original says, and that the difference between those two statements can be significant. She asked Ellen at their first substantive meeting to bring all original documents related to the estate. Ellen brought what she had: the will, the property deed, the brokerage account documentation, and the limited power of attorney from the folder in Daniel's office. Pamela reviewed each document. When she reached the power of attorney, she read it carefully, not quickly, not as a formality, but as a professional reads a legal instrument when she is trying to understand exactly what it authorized and exactly what it did not. She read it once. She read it again. Then she looked up and asked for Harold's copy, the one that had been filed with the Franklin County Recorder's Office. The county recorder's office produced the filed version within 2 business days. Pamela placed the 2 documents side by side on her desk and compared them, section by section. Ellen was not present for this comparison. Pamela called her afterward. She said, "Ellen, I need you to come in." Ellen came in. Pamela placed both documents on the conference table, side by side, the same way she had compared them at her desk. She pointed to page 2 of Ellen's original copy and to the corresponding page of the filed version. She said, "Without preliminary, there is a clause in the filed version that is not in the document you signed." Ellen looked at the pages. She looked at the clause, a paragraph, 3 sentences, granting the attorney in fact authority to transfer real property to a limited liability company in which the attorney in fact held a personal ownership interest. She looked at the corresponding location in her original. The paragraph was not there. The page moved from one section to the next without the paragraph. She looked back at the filed version. The paragraph was there. She is a graphic designer. She noticed it immediately once she knew to look. The typeface was the same, but the kerning, the spacing between letters, was marginally different in the inserted paragraph. The margin alignment was slightly off. A professional typesetter would have noticed it without being told. A document forensics examiner would not need to look for long. Ellen sat with the 2 documents for a long time. Pamela did not fill the silence. Ellen said, "I trusted him because Daniel trusted him." Pamela said nothing. Ellen said, "He changed the document after I signed it." She said it slowly, as if hearing the sentence for the first time, which she was. Then she said, "What do I do?" Pamela said, "We start with the county recorder's office." They had already started. The filed copy was already in Pamela's folder. The next step was documentation. Pamela retained a document forensics examiner, a specialist in questioned documents who had worked on similar cases for the Franklin County courts and was certified in forensic document examination. He received both copies of the power of attorney and conducted a comparative analysis over a period of 11 days. His report was 44 pages. The conclusion was stated in the first paragraph and repeated in the summary. The additional clause in the filed version of the power of attorney was not present in the original signed document. The typographic analysis indicated that the clause had been inserted into the document after the original was printed, using a word processing system that produced marginally different character spacing in the inserted text. The clause appeared on a page that showed evidence of having been separated from and reattached to the original binding. Microscopic fiber analysis identified adhesive residue at the page margin consistent with a page replacement. The clause had been added. The page had been replaced. The document had been altered after Ellen's signature and before filing. Pamela filed an emergency motion to void the property transfer to the LLC, citing fraud and unauthorized modification of the authorizing instrument, and requesting a temporary restraining order on any further asset transfers from the LLC pending adjudication. The Franklin County Court of Common Pleas issued the TRO the same day. Harold received the motion through his attorney. He called Ellen directly that evening, a call she did not answer, because Pamela had told her not to accept direct communications from Harold, and she was following that instruction. He left a voicemail. She did not listen to it. She set her phone face down on the kitchen counter and made tea. She called Pamela afterward. Pamela said, "Good. Don't listen to the voicemail. Don't call him back." Ellen said, "He was in charge of everything for 8 months." Pamela said, "I know. We're going to find out what he did with all of it." Ellen said, is it going to come back?" Pamela said, "That's what we're working toward." Let me tell you about the procedural period because it was not brief. Harold's attorney argued, in the initial response to Pamela's motion, that the LC transfer had been within the scope of the power of attorney as recorded, that is, within the scope of the filed version, including the inserted clause, and that any discrepancy between copies was a clerical issue that did not affect the validity of the transfer. It was an argument that required a particular confidence, the confidence of someone who has decided that the existence of a document in the county records is equivalent to the legitimacy of the document's contents. Pamela's written response was the forensic report. She did not argue. She produced the evidence, accompanied by the applicable Ohio statute, Ohio Revised Code 1337. 29, which provides that a power of attorney granting authority to benefit the attorney-in-fact personally, including through a transfer to an entity in which the attorney-in-fact holds an interest, constitutes a self-dealing transaction requiring explicit written consent from the principal. Ellen had not given explicit written consent to a self-dealing transaction. The clause authorizing the LLC transfer to an entity Harold controlled was a self-dealing clause. That clause had not been in the document she signed. It had been inserted afterward. Harold's attorney requested a continuance. The court denied it. The hearing was scheduled for late fall. Pamela and Ellen spent 4 weeks preparing, reviewing the LLC formation documents. The brokerage transfer records, the property transfer instruments, the quarterly statements Harold had sent. Roderick Hale, the title company's senior examiner who had processed the duplex transfer to the LLC, was contacted and agreed to provide a statement. He said that at the time of the transfer, he had been presented with the filed power of attorney, which had appeared complete and properly recorded, and that he had had no reason to question it. He said he had since been made aware of the discrepancy and would cooperate fully with the court proceedings. His statement confirmed the timeline of the transfer and the documents on which it had relied. Ellen attended the preparation meetings in Pamela's conference room with Daniel's original power of attorney in a folder she carried everywhere during those weeks. She had not taken it back to the office. She had it with her because it felt important to keep it close, not as a talisman exactly, but as the document that said what was true when she signed it. In the version that was clean and unaltered, in Daniel's office handwriting on the folder tab, Estate, POO, Original, she thought about Daniel during those weeks. She thought about his meticulous files and his carefully organized documents and the office she had not touched. She thought about the specific care he had taken with the paperwork of his own dying. The way he had made things navigable for whoever would need to navigate them. He had not anticipated his father. He had not anticipated that the careful navigation he had built into the system would be necessary in a litigation context rather than simply an administrative one. But the system had held. The folder had been in the office. The document had been where he would have put it. She thought, he would not be surprised that the original is the one that matters. He always kept originals. The hearing was a November morning in the Franklin County Court of Common Pleas. The courtroom was warm and hushed, and had the specific quality of institutional spaces that have witnessed a great many significant events and absorbed none of their energy. The walls were neutral. The light was fluorescent. The spaces between events had the procedural calm of a place where procedure is the point. Harold Crowley took the stand. He spoke with the measured confidence of a man who has been in professional settings his entire life and understands the performance that those settings require. He said he had acted in Ellen's best interest. He said the LLC structure had been designed to protect the estate assets. He said the quarterly statements had provided full transparency. He said any discrepancy in the documents was administrative. Pamela Cross examined him. She asked him to read aloud the scope limitation on page 1 of Ellen's original signed copy, the limitation that specified precisely what the power of attorney authorized, and by implication, what it did not. He read it. His voice was steady. When he finished, Pamela placed the forensic report on the bench before the judge and asked Harold whether the clause authorizing LLC transfer to an entity in which he personally held an interest appeared in the document he had just read. He said there may have been an administrative error. Pamela placed the page replacement analysis on the bench alongside the forensic report. The judge, a compact, careful woman in her late 50s, who read documents the way judges read documents in cases that matter, which is completely and in silence, reviewed both reports. She reviewed the side-by-side comparison of the two documents. She reviewed the typographic analysis. She looked at Harold. He was looking at the wall to his left, at a space in the institutional beige that contained nothing. The judge voided the LLC transfer. She ordered the Columbus duplex returned to Daniel's estate per the terms of the will. She ordered a full accounting of the LLC's brokerage assets. And she referred the document alteration to the Franklin County Prosecutor's Office for review of potential criminal charges. Ellen was sitting in the second row. She had Daniel's original signed copy in her lap, in its folder, the way she had been carrying it for weeks. When the judge read the order, she felt something move through her that was not triumph and was not relief exactly, but was something between them, the particular feeling of a true thing being acknowledged as true by the institutional machinery that has the authority to acknowledge it. The duplex was Daniel's. By Daniel's will, it was hers. The document that said so had been in a folder in his office for 16 months, in the office she had not touched, organized by a man who organized things carefully because he understood that care was a form of love. She did not look at Harold. She had no need to see his face. She kept her eyes on Pamela, who was collecting her documents at the counsel table with the organized efficiency of someone whose professional work has just done exactly what it was supposed to do. The duplex came back into the estate within 60 days of the court order, a process involving a corrective deed, a title company, and paperwork that Pamela managed entirely. Ellen received the first rental check under her own name in January. She deposited it in an account she had opened specifically for the rental income, in her name, with no shared authority. Harold was not charged. The Franklin County prosecutor reviewed the referral and declined to file charges, citing insufficient evidence of specific criminal intent beyond the document anomaly. A decision that Pamela described to Ellen as common in document alteration cases where intent is difficult to prove to a criminal standard. Harold sent Ellen a letter explaining himself. She identified it by the return address when it arrived, set it on the kitchen counter, and put it in the recycling bin 4 days later without opening it. She has not spoken with Harold since the hearing. He had said, "Give me the power of attorney, and I'll sort it all out." She had given it to him. He had sorted it in his own direction, using an instrument he had altered to give himself the authority he needed. And the one page she had kept, the clean original, the signed version, the document as it existed when she put her name on it, had been the proof that his version of the authority was not the version she had agreed to. Ellen's home office, Daniel's home office, is still organized the way Daniel left it. The books are in his order. The whiteboard calendar still has his handwriting on it, because she has decided, at least for now, to leave it. She has added her own folder to the filing system. A folder labeled Pamela Vance/estate/closed, and she has kept the original power of attorney in a new folder of her own making, which she filed at the front of Daniel's estate drawer where she can find it without searching. The folder is labeled, in her own handwriting, original. She does not intend to use it again. She intends to keep it. She thinks about the fact that she kept the original because Daniel kept originals, because he had built a filing system that was meant to be usable and she had used it, because she had filed the folder in his office without really thinking about what the document inside it contained or why it mattered. She had filed it the way Daniel would have. She had kept it the way Daniel kept things. And when Pamela asked for the original, she had known exactly where it was. The office still smells faintly of the coffee Daniel always had at his desk. Or perhaps she only imagines this. She has decided it doesn't matter whether she imagines it. She goes into the office every few days, for one reason or another, and the room is the room it has always been. And the document is where it needs to be. That is enough. Have you ever kept something without knowing why, and then found out why later? Have you ever maintained a habit, someone else's habit, inherited and continued without analysis, and discovered that the habit was precisely what the situation required? That is what Ellen did. She kept the original because Daniel kept originals, and Daniel kept originals because he understood, before she did, that the day would come when the original was the only document that told the truth. Sometimes the document you keep without knowing why is the only one that tells the truth. If you are managing someone else's estate, if someone has handed you a document to sign in a period of grief or exhaustion, keep your original. Keep it somewhere you can find it. If someone tells you the copy and the original are the same, look at both anyway. Pamela Vance will tell you, they are not always the same. The court will tell you which one governs. Thank you for listening today. Leave your city in the comments. I love knowing where you are. If this story stayed with you, please share it with someone who should hear it. And like this episode if it mattered. I'll see you next time. Let me go back to the early part of Ellen's marriage to Daniel, because the nature of what she lost and what she was protecting is woven into the house and the office and the filing system in ways I have not fully described. Daniel Crowley was an architect, not a famous one, not the kind who builds landmarks, but the kind who builds houses that people live in well, who pays attention to the geometry of rooms and the way light moves through windows at different hours of the day, and the relationship between inside space and outside space that determines whether a house feels like a shelter or a container. He designed the kitchen in their Short North house himself, working on it over 2 summers. Consulting Ellen repeatedly about the counter heights and the window placement and the colors, he was the kind of man who asked questions and listened to the answers. Ellen loved him for this specifically, the listening, in the way that you love people for the quality in them that you most needed and did not know you were looking for. They had been married 9 years when Daniel was diagnosed. The illness was neurological and progressive, which meant it moved by degrees and allowed time to adjust, and also meant there was always a new adjustment to make, a new threshold to cross, a new limitation to accommodate. Ellen adjusted. She adjusted the way she worked, building her freelance practice around his medical appointments and his good days and his difficult ones. She adjusted the house, in the ways that houses need to be adjusted when someone in them is becoming less mobile. She adjusted her expectations, not once but continuously, in the way that living with a progressive illness requires you to revise your picture of the future on a rolling basis and find reasons to prefer the present. She has described this period of her life, when she speaks about it, as the most concentrated experience of her life, both the hardest and the most fully inhabited. She was present for every hour of it in a way that ordinary life does not require or produce. She was tired all the time. She was also, within the tiredness, more genuinely herself than she had been in any easier period. Difficulty sometimes produces this. Sustained proximity to something that is precious and threatened can make you attend to it with an intensity that ordinary ease does not generate. Daniel died in the spring. It was what they had been moving toward for 4 years, and Ellen had known it was coming, and it came anyway with the full weight of something that cannot be known in advance, regardless of how thoroughly you have understood it intellectually. She sat at the kitchen table the morning after and drank coffee and watched the light come through the kitchen window. The window Daniel had specified, at the precise angle that put morning light on the counter where she prepared food, and felt the specific vacancy of a house where someone has been and is now definitively not. Harold arrived in that vacancy with his list and his confidence and his offer to handle everything, and Ellen said yes, because yes was the answer she could manage. She wants to be clear about this when she tells the story. She did not say yes naively. She said yes because she was exhausted, and Harold was organized, and there was a great deal to organize, and she could not at that moment see a better option. She did not suspect Harold. He was Daniel's father. Daniel had trusted him. The distrust came later, slowly, by accumulation. The better for taxes phrase used as a conversation stopper. The LLC summaries that seemed to require a specialized financial reading to evaluate properly. The sense that the estate was being managed in a direction she could not fully see. She did not act on the distrust until Pamela. She had met Pamela through a referral from a colleague whose own estate matter Pamela had handled. The referral was matter-of-fact, not alarming, presented as simply the name of a good estate attorney for when Ellen was ready to do a formal accounting. Ellen called Pamela 14 months after Daniel's death, when she was beginning to feel capable of the sustained attention that an estate accounting requires. She had not expected the accounting to produce what it produced. She had expected numbers and paperwork. She had not expected the side-by-side comparison. What she had done, without knowing it was preparatory, was keep Daniel's office. She had not let Harold into the office in the months he was managing the estate. He had not asked. He had focused on the documents he had: the filed power of attorney, the property records, the brokerage accounts. He had not asked for Ellen's copy of the power of attorney because the copy she had was irrelevant to his purposes. He had filed the version that served his purposes, and as long as Ellen's copy remained unexamined, the divergence between the two versions was invisible. Pamela examined it. The forensic examiner's report, those 44 pages of comparative document analysis, is something Ellen has read only once. She received it from Pamela when the proceedings were complete, and she sat with it for an afternoon, reading it the way you read documents about something that has already been decided, not to determine the outcome, but to understand the mechanism. The examiner was precise and technical, and the report described in the language of his specialty. What Harold had done to the document with a thoroughness that was almost more than she needed to know. What she understood reading the report was that Harold had been deliberate, not impulsive, not opportunistic in a moment of confusion. Deliberate. He had obtained the signed document. He had modified it. He had filed the modified version. He had then proceeded to execute transfers that the modified version authorized and the original did not. This was not a clerical error. This was a planned series of actions that required time and effort and a specific kind of calculation about whether anyone would ever compare the two copies. His calculation, she thought, had probably been correct in most cases. Most people do not keep original signed copies of power of attorney documents in accessible folders. Most people assume that the filed version and the signed version are the same document. His error was assuming that Ellen was most people. She is, in some ways, not most people. She is a designer who notices kerning. She is the wife of a meticulous man who taught her, without instruction, how to file things. She is a person who did not touch the office for 14 months and therefore did not disturb the folder that was already correctly filed. His error was not that he failed to anticipate her. His error was that he failed to anticipate Daniel. The duplex has a particular history that belongs in this story, because it was Daniel's project before it became a legal dispute. He had purchased it 12 years ago, 3 years before the diagnosis, as an investment property he intended to eventually renovate. The Italian village neighborhood where it sat was in the early phase of what has since become a significant revitalization. And Daniel had bought the duplex because he could see what the neighborhood would become, in the same way he could see what a house would become when he looked at its bones and its light and its proportion. He had a landlord's relationship with it: tenant management, maintenance scheduling, the quarterly income that went into the investment account. But he also had an architect's relationship with it, in that he had drawn renovation plans for it that he had never executed, and that were still in the files in his office, in the drawer labeled Projects, Future. Ellen has not looked at the renovation plans. She intends to. Eventually, she is not ready to be the person who decides what the duplex becomes. She is still in the period of simply being the person who owns it, which is itself a new position that she is inhabiting carefully. The rental income arrives monthly. She manages the property management relationship herself now. Harold had been managing it, and one of the first things she did after the TRO was issued was contact the property management company and establish herself as the sole point of contact. This required paperwork, which Pamela handled. The property management company was cooperative. The tenants, who had been paying rent to the LLC account for 8 months, were notified of the change through the property manager. They asked no questions. They had a new account number and a corrected payee. The income resumed to Ellen's account without interruption. She walked through the duplex once, in February, 6 weeks after the court order. She went with the property manager, who showed her the units and introduced her to both sets of tenants. The building had been maintained correctly. Harold had not been neglecting the property. She gave him that much. The tenants were long-term and responsible. The building was in good condition. Daniel's renovation plans, had they been executed, would have been an improvement, but not a rescue. She stood in the second-floor unit for a few minutes while the property manager spoke with the tenants about a minor maintenance item. The unit had south-facing windows, and the February afternoon light was low and direct, and came in at the angle that Daniel would have calculated when he bought the building, the angle that made the interior bright without being harsh. She thought about his renovation plans in the drawer. She thought, he knew what this could be. She thought, maybe I should look at the plans. She has not yet. She will. Pamela closed the case file in March and sent a final billing summary in a brief letter, noting that the matter was resolved and wishing Ellen well. Ellen read the letter at her kitchen table, and then wrote a reply by hand on the notepaper she uses for correspondence, a design she had made herself years ago, with a small geometric motif in the corner that was the first piece of graphic design work she had done that she was genuinely proud of. She thanked Pamela. She said, "The document mattered because Daniel kept everything, and I kept everything because he did, and I hope someone is telling this story somewhere for people who need to hear it." Pamela wrote back, "I hope someone is too." Let me tell you something about Harold's letter, which Ellen put in the recycling bin without opening. She does not regret not reading it. She has examined this choice several times, not from guilt, but from the specific self-awareness of someone who wants to understand her own decisions clearly. She decided not to read it because she understood, before opening it, what it would contain: an explanation, an accounting of his reasoning, a description of his intentions as he understood them, possibly an expression of regret. She understood that none of these things would be untrue in Harold's telling, and that none of them would change what the document had said, or what the court had found, or what had happened in the second row of a Franklin County courtroom in November. She did not need his explanation of himself. She had the documents. The documents were sufficient. She has not reached out to any other member of the Crowley family. Daniel's brother, a quieter man who had stayed largely uninvolved in the estate proceedings, sent her a card after the hearing that said, in handwriting that reminded her of Daniel's, "I'm sorry." She appreciated the card. She did not respond. She is not ready to navigate those relationships, and she has decided not to force herself to be ready. She will do it when she is, and not before. She is good at knowing what she is ready for. 4 years of caring for someone with a progressive illness teaches you this. It teaches you to be honest with yourself about your own capacity, and to match your commitments to that capacity, rather than to what you think you ought to feel ready for. She is not ready to speak to the Crowley family. She is not ready to look at the renovation plans. She is ready to manage the duplex and go to the Short North coffee shops and work on her design clients and sit in Daniel's office sometimes, where the books are in his order and the whiteboard calendar still has his handwriting. She is ready to know that the original document is in the folder where she filed it. That is the readiness that matters most right now. There is a professional dimension to this story that I have not addressed directly, and it belongs here. Ellen is a graphic designer. She has been, since the hearing, the person among her professional colleagues and friends who mentions when documents are mentioned, when estates come up in conversation, when someone describes a relative who is handling their affairs. The particular importance of keeping your original signed copy of any legal instrument. She does not tell this as her story, most of the time. She tells it as a general professional observation about documents, which is what it is, and which she has come to understand is useful information for people who have not had reason to learn it another way. She has also, since the hearing, looked at power of attorney documents differently in the professional context. She was asked to review design materials for a nonprofit that provides estate planning resources to elderly residents in Franklin County, a project she took on through a colleague's referral, and when she sat with the nonprofit staff to understand their work. She found herself describing in abstract terms the specific risk of assuming that the filed version and the signed version of a legal document are identical. The nonprofit's attorney listened and then said, "Can you put that in plain language for the guide we're updating?" Ellen said she could try. The guide now includes a paragraph, in the section on powers of attorney, that advises people to keep their original signed copy in a secure location they control, and to compare it to any filed version if questions arise. She wrote that paragraph from memory. It did not take long. She thinks about document design differently now, not in a complicated way, but in the way that specific professional experience reshapes a general professional perspective. She has always been attentive to what a document says visually, what its format communicates, how its structure directs attention, where the eye moves and what the eye registers. She now thinks about what a document says legally, and about the relationship between a document's visual presentation and its legal force. A clause inserted into a power of attorney after the fact, on a replaced page, is visually indistinguishable from the original to the untrained eye. It requires a forensic examiner to confirm what a designer might suspect from the kerning in the margin. The visual and the legal are not separate registers of the same document. They are entangled, and the entanglement matters. She has not been able to explain this connection fully to colleagues who ask about her estate case. She ends up saying something approximate, the document was altered, and someone who reads documents carefully noticed something that didn't look right. The forensic examiner confirmed it. That's the short version. The long version is that she has been reading documents her whole professional life, and she noticed the kerning. And the kerning was the first crack in the story Harold had filed with the county. She noticed it. Then Pamela noticed it. Then the examiner confirmed it. Then the court acted on it. The document that Daniel had filed, the original, the clean signed copy in the folder in his office, was the counter-evidence. Ellen's eye was the first witness. The examiner was the expert. The court was the final authority. But Daniel's filing habit was the foundation of all of it. She sits in the office sometimes in the late afternoon, with the light coming through the window at the angle Daniel specified when he designed the extension, and she reads. She keeps the original power of attorney folder in the drawer where it belongs. She has added her own labeled dividers to Daniel's filing system, not to change it, but to continue it, to add the chapters that came after his chapter ended. The system is both his and hers now. She did not design it. She inherited it and extended it, the way you inherit and extend a habit that was made well enough to keep. She does not cry in the office, most of the time. Sometimes she does. She allows this. It is, after all, his room. She is just the person who uses it now, with his books in their order and the whiteboard calendar he kept and the renovation plans still in the projects. Future drawer, waiting for the morning she is ready to look at them and decide what the duplex could become. She thinks she will look at them soon. She thinks she is almost ready. One last scene, and then this story closes. It was the evening after the court hearing. Ellen drove home from downtown Columbus in the November dark, with a case file in a tote bag on the passenger seat and Daniel's original power of attorney folder on top of the case file, where she could see it if she glanced over. She parked in the driveway of the short north house, their house, her house now, and sat for a moment in the car before going inside. She thought about Daniel. Not the Daniel of the last year of his illness, not the Daniel of the difficult months, but the Daniel of the first year they had known each other, when he was showing her the house he had found in the short north and describing what he saw in it, the proportion of the rooms, the quality of the light, the way the kitchen would work once the window was placed correctly. He had seen the house as it could be rather than as it was, and he had explained what he saw with a patience and a precision that she had recognized, even then, as a form of love. This is how I see things. I want you to see them this way too. She understood that the filing system in the office was the same love in a different form. This is how I organize what matters. I want you to be able to find it. She had found it. She had found it in the way he had made it possible to find it. And Pamela had used it, and the examiner had confirmed it, and the court had acted on it, and the duplex was coming back to her, Daniel's duplex, with his renovation plans in the drawer, with the south-facing windows and the winter light he would have appreciated. She picked up the tote bag and the folder and went inside. She turned on the kitchen light, the light over the counter Daniel had specified, at the height he had calculated, casting the particular warm glow he had wanted there. She set the folder on the counter. She made dinner. She ate at the kitchen table. She washed the dishes. She carried the folder to the office and filed it in the front of the estate drawer, where she could find it in 30 seconds. She looked at the room for a moment, the books in their order, the whiteboard calendar, the renovation plans and projects, future. She turned off the light and closed the door. Sometimes the document you keep without knowing why is the only one that tells the truth. Ellen kept it because Daniel kept everything. That is the whole reason. That is also the whole story. Keep your originals. Know where they are. And if someone tells you they can handle everything, know what the document actually says before you hand it over. Thank you for listening today. Leave me your city in the comments, and please share this with someone who needs to hear it, because somewhere out there, someone has a folder they haven't opened yet, and the right document is inside. I'll see you next time. There is something I did not tell you about Roderick Hale, the title company examiner, and it belongs here. He called Pamela 2 weeks after the hearing. He said he had been thinking about the case since the court order, and that he wanted to add something to the record, not legally because the proceedings were closed, but professionally. He said that in his 23 years of examining property title transfers, he had processed hundreds of power of attorney instruments. He had never, he said, requested the principal's signed copy for comparison with the filed version. It had not been part of his process. The filed version was the controlling document. He had processed what was filed. He said, "I will be changing my process. I will be requesting the original signed copy for verification before processing any future POA-based transfer." Pamela thanked him. She mentioned the call to Ellen at their next meeting. Ellen said, "He didn't do anything wrong." Pamela said, "No, but he's doing something right now." Ellen thought about that. She thought about the ways that a single case, a single pair of documents compared side by side in an attorney's conference room, could extend outward through the people who encountered it and change the practices of professionals who had not previously had reason to change them. Roderick Hale would now request original copies. He would compare them. He would not process transfers where the comparison produced a discrepancy. Other people, perhaps, whose title work had previously moved through without that check, would find themselves facing a comparison they had not anticipated. The document Harold had altered had been intended to give him access to something that was not his. Instead, it had, through the forensic examiner, the court, the TRO, the hearing, and now the changed professional practice of a title examiner in Columbus, created a small but real increment of protection for people who had not yet been in Ellen's situation. That is not the kind of justice that appears in movies. It is the kind that happens incrementally, in professional practice changes and updated guidance documents, and a paragraph in a nonprofit's estate planning guide that one person wrote from memory in an afternoon. Ellen is that person. She has been, since the hearing, doing this kind of quiet work, not as an activist or an advocate, not with any explicit mission, but in the ordinary way of someone who has learned something specific and useful and cannot unknow it, and who mentions it when mentioning it might matter. She is also, in the months since the hearing, beginning to sleep better. This is the change she notices most concretely in her daily life. 4 years of caregiving and 14 months of grieving and the months of the proceedings have a cumulative weight, and that weight is beginning to lift in the specific way that weight lifts when the acute phase of something long and difficult is genuinely over. She is sleeping 7 hours, sometimes 8. She wakes in the short north house, and the morning is the morning, without the specific freight of worry or proceeding or the next document to be reviewed. She goes into Daniel's office. She reads. She designs. She manages the rental property. She looks at the window he specified, at the light he planned, in the house he built carefully for both of them, carefully enough that it still holds.